Believe it or not, lawyers watch jurors and watch you, and you've all been paying very close attention to everything you've received, and you've received a lot of evidence over the last 4 days. And as you've seen, in real life, a murder of a human being is much different than people imagine, much different than you see on TV. In real life, up close, the murder of a human being is raw. It is emotional. It has a great sense of finality to it. Now, the evidence you've received, and I'm going to talk about that evidence quite a bit. But first, I want to talk to you about something that you all were asking some questions about last week. Last week, remember, during jury selection, we did talk to you in that vacuum where we could not talk to you about what the actual law is. And I agree with the judge. His instructions are the instructions to follow. If there's anything different in mind, follow his instructions. But I want to go through some of those instructions with you now, and then talk about how the law fits those instructions and how the state has proven the charges in this case, the charge in this case beyond a reasonable doubt. There is only one count you're considering. And again, you're going to get these jury instructions from Judge Zambrano. At the very top, when it's discussing count one, before going into the elements of count one. And that's an important word I want to talk about, elements of count one. For every charge in Florida, every criminal offense is made up of certain elements. It might be 2 elements, 3 elements, 4 elements, and the state has to prove each and every element. But it gives you guidance of how we prove the charge. Before getting to the elements, the instructions are going to tell you there are 2 ways. You guys already know this from last week, that someone can be convicted of first-degree murder. That premeditated murder we talked about last week, and a felony murder, both of a law enforcement officer. So there's 2 ways we can prove first-degree murder of a law enforcement officer. We can prove it by proving premeditated and felony murder. The instructions you need to understand are long. There's nothing we can do about that. They are also very repetitive. And at times, they'll seem a little out of order. And this is one of those examples, because the verdict instruction is way at the end, almost at the very end of the jury instruction packet that you were going to get. But this instruction tells you, I'll have to read it from my laptop, that if you return a verdict of guilty to the charge of first-degree murder of a law enforcement officer, it's not necessary that you all agree the state proved first-degree premeditated murder of a law enforcement officer, and it's not necessary that you all agree the state approved first-degree felony murder of a law enforcement officer. So what that means, at the top, you've got first-degree murder, law enforcement officer. There are 2 theories the state can prove. Again, from last week, felony murder of a law enforcement officer, premeditated murder of a law enforcement officer. As long as you all agree we've proven one or the other, the appropriate verdict is guilty of first-degree murder. So all 12 of you could believe we proved both of them, which I submit to you the evidence has. But 9 of you could say, well, I think the state's proved premeditated murder. 3 of you could say, I think the state's proved felony murder. But as long as you all agree that we proved one or the other, the appropriate verdict is guilty as charged of of first-degree murder of a law enforcement officer. So again, you have the 2 options. As long as you all agree on one of them. Here is the instruction for first-degree premeditated murder of a law enforcement officer. A few moments ago, I talked to you about elements. This is an instruction where there are 6 elements. 6 elements for the state to prove. I'm going to come back to this in a minute, but I want you guys to see what the instruction looks like first before I talk about each element. This is in the same instruction, and you're going to see jury instructions like to give you definitions for some things. So again, I'm going to come back to these definitions in a minute, but the instruction on first-degree murder of a law enforcement officer, premeditated kind, defines act, defines killing with premeditation in 2 paragraphs. Not surprisingly, it defines what a law enforcement officer is. It also defines an employing agency. And again, I'll come back to those in a moment. And this is an instruction you are going to see over and over and over again in these jury instructions. It's going to come at the end of first-degree premeditated murder of a law enforcement officer. It's going to come in the instruction for first-degree felony murder of a law enforcement officer. It reads, a person is not justified in using force to resist an arrest by a law enforcement officer, or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer is acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. However, if an officer uses excessive force to make an arrest, then a person is justified in the use of reasonable force to defend himself, but only to the extent he reasonably believes such force is necessary. And I'm going to talk about this instruction more, but this is one, when I talk about repetitive, you will get it over and over again in these instructions. Now here's the other option. We talked briefly about the instruction for first-degree premeditated murder of a law enforcement officer. Here's the other one. Felony murder. 6 elements as well. I'm going to come back to them and talk about them. And you're going to see even the elements are kind of similar between felony murder and premeditated murder. Felony murder is a long instruction. Tells you you don't need premeditation. But you do have to prove the felony. So the state has to prove the felony that we're alleging the defendant was committing when he killed Officer Rain. So the instruction will give you the definition of that felony. As I said, you get it over and over again. Here's that instruction about good faith, legal duty, and excessive force. Repetitiveness, law enforcement officer, employing agency. And I want to spend just one moment on this instruction because you will get lesser included offenses. I want you to think about lesser included offenses as kind of stairs. It's a step down. So the highest charged offense, first degree murder, law enforcement officer. A step down or a lesser included offense is first degree murder. A step down is second degree murder of a law enforcement officer. And that's what this instruction tells you. It tells you all the steps down, and then you get those definitions as well. So just to kind of explain it a little bit, I've got the first degree premeditated instruction I talked about that I'm going to spend some time talking about. This is the proof. First degree murder of a law enforcement officer. The lesser included offense of just first degree murder. Not surprisingly, we don't have to prove that Jason Rayner was a law enforcement officer for that lesser. We don't have to prove that Arthur Wallace knew that Jason Rayner was a law enforcement officer. And we don't have to prove that he's engaged in a lawful performance of a legal duty. So that's why it's a step down. Now the evidence has proven the highest offense. So let's go back to that clean instruction. I want to talk to you about these elements now. Again, this is the first option for first degree murder, the premeditated kind. These elements, a lot of them are very easy for you to look at, and very easy for the state to prove. Jason Rayner is dead. Obviously, Officer Jason Rayner is dead. You heard from the medical examiner. You saw autopsy photos. There is no doubt that Officer Jason Rayner is dead. The death was caused by the criminal act of Arthur Wallace. Again, overwhelming evidence to prove this element. The defendant admitted on the stand that he killed Officer Jason Rayner. It is on video. Him having a conversation with Rayner and then shooting Officer Jason Rayner when he approached him. He was so fearless that he refused to sit down over and over again. So fearless that he wouldn't even respond to the officer's comments. And so fearless that he aggressively engaged Officer Rayner when he tried to call in dispatch. That cuts against a self-defense argument. The actions after as well. His behavior after he shoots Officer Rayner also proves this was not self-defense. Just wasn't. He ran. He ran far, and he ran fast, and he tried to cover his tracks as best he could. He booked up to Jacksonville, cut across to Gainesville. After making his social media post, when he could have been calling anonymously, 911 or some way to get Officer Rayner some help, who he just left for dead behind 133 Kingston. But no, he goes all the way to Gainesville. First calls his dad. His dad's not willing to help him. Then he calls his brother. His brother gives him a ride up to the Atlanta area, Snellville, Georgia. He never says anything around this Bodison about self-defense. He never says anything about self-defense. In his last message, what he thought was his last message to his followers, he doesn't say anything about defending himself. Behavior after shows this was not self-defense. And guess what's in the self-defense instruction one more time? This is the most important place where you will see this instruction. Same one, I'm not going to read it again. A law enforcement officer in the execution of a legal duty, in good faith, a person cannot use force unless the force is excessive, which again is not present in this case. There is no excessive force used. And I want you to remember some of the defendant's statements. One of the issues with self-defense is there another option? Justifiable use of deadly force needs to be the only option, essentially. And Mr. Wallace admitted over and over again on the stand about the other options he had. I could have sat down and complied. Could have sat down, but I wanted to walk away. Initially, could have sat down, yes. 0 injuries, excessive force. Yes, there has to be excessive force and there's 0 injuries. He testified to that. I had 0 injuries. I was fine. Mr. Lewis asked him, he asked you to sit in the car. Didn't listen, did you? No. And here's the biggest one. Mr. Lewis asked him, all you had to do to defuse the situation was listen to his commands. And the defendant's response was yes. And that should have been the end of this. It should not have ended with Officer Rayner having a bullet in his head and his life taken from him. Because Mr. Wallace didn't want to listen to a pig's commands. Because he told his followers, when they come, I'm not backing down. And he didn't. And Officer Rayner is dead for that reason. Ladies and gentlemen, Othel Wallace was going to murder a law enforcement officer. It was a matter of where, when, and who he would kill. Tragically, the where was Daytona Beach, the when was June 23rd of 2021, and the who was an officer who was patrolling an area doing his job. And because the evidence is overwhelming, I ask that you use your common sense, follow the law as instructed by the judge, and if you do so, the appropriate verdict is to find Mr. Wallace guilty as charged of first-degree murder of a law enforcement officer. So thank you for your time.
Thank you. We're going to take a restroom break, about 10 minutes. All rise, jury. Thanks, be seated. Are we ready for the jury? All right, bring the jury in, please.
Yes, let me.
All rise for the jury. The jury is present. You may be seated. Defense, you're closing. Court is pleased.
Members of the jury, good evening. If there's one thing that I think we can all agree about, it's that this has been a very long and stressful couple of weeks. And this morning, when I was leaving my house, my wife gave me a cup of coffee and she said, "I know that this is going to be a long and stressful day. I read your mind." I was thinking about that on the drive to the courthouse, and it really underscored what this case comes down to, which is that the state of Florida wants you to read both of Wallace's mind. The government has summoned you here today to deliberate on the most serious accusation that we can lodge on another one of our citizens. And with your deliberations comes the responsibility to fairly consider all of the evidence, all of the testimony. And in doing so, you have to be convinced that the state of Florida has met its high and heavy burden to convince you beyond a reasonable doubt that Mr. Wallace is guilty. And the state has not met its burden. The state of Florida has to prove either that Mr. Wallace, in a premeditated fashion, killed Mr. Rayner, or that he was committing the felony of resisting with violence at the time, and that caused his death. And in doing so, the state has relied on what I would categorize on an alphabet soup of information to you. They presented a day of testimony on Monday, essentially about an email that Jason Rayner may have considered, that he may have opened, that he possibly relied on. The other day we heard the state of Florida wants you to read Mr. Wallace's mind. The state would have you believe that when Mr. Wallace came home after visiting his children, that he was sitting there with such hatred and malice in his mind that he was ready to essentially execute a police officer steps from where he would lay his head. And in reaching your determination, you need to make an individual assessment. Each and every one of you needs to make an individual assessment about whether the state has met its burden, about whether the state has ignored or oversimplified or completely disregarded what's at issue in this case. The state is asking you to read his mind. And in participating in a fair and full deliberation of what actually matters in this case, I believe that the law requires you to consider how Mr. Rayner's actions affected Mr. Wallace's state of mind. We heard all of this testimony from the medical examiner, from the FDLE agents, from the ATF agents in Georgia, and all of these guns and everything. Is that a distraction from the heart of the issue here? Is that a distraction from the state of mind that your government must prove to you beyond a reasonable doubt existed? Why would the state spend so much time on presenting you evidence that does not get to the heart of the matter? Try to impress you with the fancy badges and the titles and the credentials? Distract you from the fact that if you look at the video, you will have to ignore the fact that Jason Rayner was not acting on any suspicion. He was just in there on a whim. Mr. Wallace was not doing anything wrong. Mr. Wallace didn't come up to Mr. Rayner and put his hands on him and ask him a question at first and get in his face and push him back into his vehicle. That's how this encounter started. So instead of embracing that and diving in with every witness on the video and presenting to you evidence of peace of mind, they presented you this alphabet soup of FBI and ATF and the Georgia police and the officer Toluta that came in here and gave you redundant testimony about what my client's girlfriend said when she was presented with the fact that Othel Wallace was on the body camera. Members of the jury, if Jason Rayner was acting lawfully, then we rightfully concede, as the law allows, that he had the ability to detain Mr. Wallace. And Mr. Wallace doesn't want to distract you from the issues. He doesn't want to put up a dog and pony show over here and try to impress you. He acknowledges the fact that law enforcement officers have a difficult job. They have a dangerous job. That there's considerable leeway given to them when they have to make these on-the-scene decisions. And lawfulness can mean that you can get it wrong. You can be in good faith pursuing a vehicle that looks close, pursuing a suspect that looks similar, looking into a circumstance that looks suspicious, but ultimately it turns out to be unfounded. So the question before you is the reasonableness of the actions. Are you acting in good faith? So when the state of Florida is presenting its case to you throughout this week, and even the remarks of the government prosecutor, and they're saying, here's a possible explanation. It could have been this. It could have been that. The state wants you to read my client's mind, but they're not presenting any evidence to the heart of the matter. There's only 3 elements that are in dispute. I disagree with the government that we have conceded that death was caused by the criminal act of Othel Wallace. There was no criminal act. It was self-defense. It was not premeditated. Mr. Rayner was not engaged in his lawful duty. Now, certainly there are many ways that a person can come to this reading of one's mind. It could be your intimate partner. You're with that person every day. You can finish each other's sentences, give them coffee when they need it. Or a 30-second video. So the state wants you to read Othel Wallace's mind in a 30-second video. Now there's certain things that you could watch in a 30-second video depiction of a law enforcement officer, and it would not be very hard to discern the majority of what's going on in the officer's mind. Video of an officer writing a speeding ticket, running radar, walking someone to the courthouse with handcuffs. But in this video, we don't see any of those consistent activities with police functions. It's very convenient that the state ignores to you in their presentation the fact that Mr. Bedard previously testified that Officer Rayner's actions were not consistent with the way one approaches a high-risk vehicle. He quarreled with me about that, and then I had to remind him with his sworn deposition testimony just a month ago, where he stated just that. He stated, this is not consistent with the way that an officer would approach a high-risk vehicle. So you have to ask yourself, does Officer Rayner's actions on the video undermine premeditation? Does it undermine lawful duty? And a fair deliberation in this case requires you internally and amongst one another to take into consideration that Mr. Wallace is in fact permitted to using even deadly force against a law enforcement officer. And again, it's very convenient in the way that the state is trying to ignore the fact and suggest to you that under no circumstance can an individual use any type of force against a law enforcement officer. Well, when Judge Zambrano instructs you on the law, the opposite is true. That the state of Florida needs to show to you that there was in good faith, that there was a lawful duty that was being performed. And if those things aren't happening, and Mr. Wallace is in a position where he reasonably feels for his life, then he can in fact use reasonable force. If Mr. Wallace reasonably believed that the force was excessive, then he can use the amount of force that he reasonably feels is necessary. And let's talk a little bit about that. The state's evidence is inconsistent with premeditation. What's confusing to me, and what I hope is confusing to each and every...
It's confusing to him. I think that's the proper argument.
Okay. Overall, go ahead.
Mr. Jury, what's confusing about the state's evidence in the state's case is the fact that they want you to ignore, completely ignore and disregard that Mr. Rayner was wrong about the stolen vehicle. He was wrong about the stolen vehicle. So if he's wrong about the stolen vehicle, and Mr. Wallace is not doing anything wrong in his car, then how does Mr. Wallace feel when he's sitting in there doing nothing wrong after visiting his kids, getting out of his vehicle, about to go inside, and he's abruptly met with a light in his face and a person blocking his only escape from his vehicle? How is that not a factor in a human being's state of mind? The essence of humanity, something that we can all share, about that fight or flight mentality when you're presented with something startling, when you're backed into a corner and your blood pressure raises and you get stressed out and you start to stress and you can't think clearly. The state would have you just ignore all of that because Jason Rayner wore a uniform. And then he walked up to somebody. The state wants you to disregard the fact that we live in the United States of America and you do not have to just submit on a whim to an officer's commands or directives. The decision must be present in the mind at the time of the killing. Must allow enough reflection. When Mr. Wallace is sitting in his car not doing anything wrong, and he has Mr. Rayner's hands on him for the entirety of the encounter, pulling him, grabbing him, eventually choking him with the back of his collar, is it reasonable for you to believe that in his mind he's thinking, oh, this is the opportunity I've been waiting for? I'm plotting the execution of this pig? Or is the real human circumstance a person who is surprised, caught off guard, and then in a defensive posture and reacting to the provocation that they did not deserve? That's what's shown in the video, members of the jury. What's shown in the video is a man that's not acting consistent with this radicalized cop killer that the state of Florida would have you believe that Mr. Wallace is. Is Mr. Wallace's salutation of sir? He calls him sir. This man who the state claims has been lying in wait to execute a police officer at his doorstep calls him sir. Asks a basic question. How is that premeditation? How is that a premeditated intent to kill when you arguably address the object of your ire with a formal salutation? If you find the state's evidence inadequate and inconsistent on whether Mr. Rayner was acting lawfully and in good faith, then how can he be guilty at all? State would have you believe that the conversation ends because Othel Wallace answered Mr. Lewis's screaming match to him and said, "Oh, well, all you had to do to end the situation was to sit down. Just comply." Has the state of Florida presented to you a credible amount of evidence? Look at all the evidence. Mr. Wallace is literally on trial for his life, and he embraces all of the evidence in the case, and he encourages every single one of you.
He's actually talking about the defendant encouraged them. That's improper.
Overruled.
Mr. Wallace, the person that's on trial here, the human being for whom you have been summoned to consider whether he is guilty of a heinous crime, wants you to look at all of the evidence in the case. And when you look at all of the evidence in the case, among it you will not find any consistent narrative which shows that Mr. Wallace did not have the right to walk away from that encounter. He had every right to walk away from that encounter. As much as the state of Florida would like you to look away and think about all of the fancy apprehension and the crime mapping and the FDLE labs, which show nothing about the disputed issues here. We don't contest that my client's DNA is on the gun or on the shell casing or Mr. Rayner's DNA is on that. None of that matters. None of it. All you had to do was sit down. He doesn't have to sit down. He has the right to walk away because he's not doing anything wrong. So if in your mind you're not doing anything wrong and you have the right to walk away, what is going through Othel Wallace's mind? When a light's shown in his face, when somebody abruptly comes and blocks his only escape, when somebody puts his hand on him, what's going through his mind? The way the state has presented this case, you would think that the roles were reversed and that the culmination of the video was the result of Othel Wallace coming up with an erroneous suspicion, quickly approaching the side, grabbing, twisting, not answering basic, humane, courteous questions. Mr. Wallace acted in response to these actions of Mr. Rayner. How have they shown premeditation? So, what is the state of Mr. Wallace's mind when Mr. Rayner is performing a barrage of actions on him? Is the state's evidence in this case eliminated a self-defense claim? Because it's the state of Florida's burden to prove that the evidence that it has presented to you overcomes his claim of self-defense. What are the circumstances of the killing and the conduct of the accused? Now, look at the social media evidence, members of the jury. Mr. Wallace didn't deny that. He testified to you that he regrets that. It's an absolutely stupid way, an unproductive way to communicate frustrations about what was going on in the world. And it's very unfortunate that you are now tasked with reviewing that evidence in light of what happened on the video. And we acknowledge that. Now, what's interesting about the social media evidence and the way that it was presented is it's consistent with what I've been discussing this entire time. This look over here about all of the elements that aren't in dispute, and we'll pile on all this evidence, and then maybe that will be enough to get to what actually matters. So the state of Florida would have you believe that you are able to read Mr. Wallace's mind with what was it, 3 social media posts. We heard testimony, members of the jury, of tens of thousands of pages of social media. And the state of Florida, who has the burden in this case, brings the charges, investigates. We heard all about this big investigation, coming down to the moment of truth. We're in the arena, and they give you 3 posts, 3 social media activities of my client a few weeks before. Is that the full picture? Similarly, members of the jury, I'd like you to consider the fact that when you are taking all of the evidence back with you, the state of Florida has similarly cherry-picked just a few still shots of the slowed down enhanced video. When you look at the defense exhibit, you're going to get a zip drive with about 150 of them on there. And I'd like you to look at every single one of them. Because what the state of Florida dodged around and didn't have any witnesses talk about or discuss the appropriateness of was the horse collar, or the grabbing, or the twisting. Sir, he's not yelling at the cop. He doesn't come up and say pig. He doesn't have his gun waiting on his lap, waiting for the opportunity to execute a police officer. How is that consistent with someone who is so malign towards an officer weeks before? It's not. It is absolutely inconsistent. The social media, in this case, also, at least the way that it's presented, completely ignores the context. Completely ignores it. Now, members of the jury, again, Mr. Wallace's testimony and my sentiments on his behalf in no way condone the violent rhetoric expressed in the social media. It's not productive. It's counterproductive. But there is a vast distinction in a person who looks like Mr. Wallace, who's lived his entire life in a high-crime area, and who is observing people who look like him when they're engaged with a law enforcement officer, doing something wrong or not, and wind up dead. When Detective Smith took the stand and I asked him about that, he almost seemed contemptuous that I would even suggest that there was some context to this. So you have to ask yourself, is his righteous indignation justified? Yes, absolutely. I think if you're a fair-minded, non-prejudicial person with common sense, you can agree that it is absolutely unacceptable about some of the things that are still happening, that have happened for hundreds of years, that Mr. Wallace carries with him through his marriage.
Sustained.
And to not even give that any context or credence? Similarly is the way the investigation unfolds. One day later, on June 24th, Mr. Wallace is charged with attempted first-degree murder. One day later. You know, Detective Donardi almost seemed surprised that he was questioned so aggressively on, was there ever any consideration about why Mr. Rayner came up to him? No. There was no mention of the stolen vehicle in the report. There was no mention of cannabis. The cannabis didn't come until they paid Ward Bedard to come in here and tell you about it. So has the state really proven beyond a reasonable doubt the significance of that social media? Or have they made a presentation to you in a light that is most favorably to their narrative, but is a distraction between the actual state of Mr. Wallace's mind? And I would suggest to you, members of the jury, that the high and heavy burden which you must deliberate has been met, is not met by 3 out of 5,000 social media posts. I understand their tone, I understand the tenor, they're disgusting, they're vile, and you need to consider them. But when you consider them with context, you consider them in light of what was going on in Mr. Wallace's mind, and you consider them in light of how he's acting in the initial exchange on the video, and how he only reacts, they have a great state of mind. Mr. Wallace was not committing a felony at the time that Mr. Rayner died. None of the other elements are in dispute. It comes down to whether Mr. Rayner was acting lawfully. And they have to prove, beyond a reasonable doubt, not probably, not, okay, here's 4 or 5 things that probably were going on at the time to prove lawfulness. He probably got the email. There's probably a joint in his hand. There's probably a lot of crime. Did you see any crime statistics? Did you see any data from that? Or did you just hear people talk about it? One of the people that you heard talk about it was Amanda Dickens. And Judge Zambrano was going to instruct you, when you're weighing all of the evidence in the case, from all of the witnesses, that there are some rules that you should apply. And Mr. Wallace encourages you to do so. And one of the things is, does the witness have an interest in the way that the case will turn out? And I would suggest to you that every single law enforcement officer in this trial has an interest in the way that this case comes out.
You know, I'm going to object to relevance of that.
Members of the jury, what I'm talking about is the law that the judge will instruct you on. Nothing else. I'm talking about the law, and what you're going to hear is the law says that you can consider whether a person has an interest in the way that the case unfolds. And one of the other items for deliberation is whether a person has made an inconsistent statement at a previous time. Well, we heard from Amanda Dickens. First of all, she allegedly has this conversation with Mr. Rayner a few minutes, really, before everything unfolds. And I'm not trying to pull wool over your eyes or make light of the situation or anything like that, but I would say it is absolutely reasonable and within common sense, even during a time of trauma, that a law enforcement officer would express some semblance of that information to someone that night, or the day after, or the week after, or the month after, or 6 months after, or a year after. However, Amanda Dickens doesn't do that. As we're approaching trial, then the epiphany from above comes and says, he said he was going to go big. Well, members of the jury, what's before you for consideration is a video of what Amanda did find to be her first recollection. The story was, I came to a trial. I searched her, and when I was done with that, he said, all right, I'm going to go look for that stolen vehicle. In a few moments, I want you to look at the video, because there's not in between the two. So how much credibility is there? I'm not saying any of that. There's a lot of person can provide testimony that's not. The state of Florida's burden. Then you can disregard. Flat out, it's not credible. Think what there. And a response by to apprehend and identify this person. Suggesting otherwise. Suggesting in the checks and balance in the system that we have is you are the deliberators of the facts in this case. Was there a rush to judgment? Oops. For the ultimate charge in this case before I would contend that if you look at the by the common sense. I mean, this is something that I understand a chance to come talk to you. Reality. Believe. A lot of cops. What better opportunity for him to be in the higher ground, heavily armed, that Mr. Wallace was aggressive, hostile, fired a shot, resisted with violence. In fact, the testimony was to the contrary. Officer Salcedo from Georgia testified that he was compliant, that he was cooperative, that he went peacefully. Mind that the how was Mr. Wallace's mindset affected by Jason Rayner's actions? And that wouldn't be an issue in dispute. Proactive initiated this. So how do we read Jason Rayner's mind? Well, 30 additional seconds of video from the safe presentation view is a complete miss. 3 seconds. Don't. So how do we read Jason Rayner's mind? Well, 30 additional seconds of video would help. Now, what's amusing from the safe presentation view is a complete missing of the mark of the importance of the 30 seconds. We agree. Don't deliberate this. The video is the entirety of the encounter between Mr. Rayner and Mr. Wallace. Agreed, end of story.
You deliberate what you want to deliberate, folks.
I agree with that 100%. If you don't have to believe anything that I say, you don't have to believe anything that the government has to say. What we say is not evidence. But members of the jury, I stand before you about the words that I expressed to you, and I will say that what I am submitting to you is backed up by the evidence in this case. And the significance of the 30 seconds of videos, it does give some insight into, at least on June 23rd, 2021, the practice of Jason Rayner. And that was after the 4 calls that he had that night, every single time he put his camera into sleep mode. Every time. You're going to have the audit trail. It's about 25 pages long. It's amongst the many exhibits that you have to look through and look at that. And the expert, the Axon expert, came in and told you just that this was a deliberate pressing of a series of buttons that hindered the 30-second look back. Again, we don't have to prove anything, and I'm not suggesting that this was some calculated thing or an accident or maybe there was privacy. If you find that cause, it's the state of Florida's burden to prove otherwise. But the fact of the matter is, on 4 occasions that evening, Jason Rayner put his camera into sleep mode. And what we also heard from multiple law enforcement officers who were with the Daytona Beach Police Department is that the policy is you keep your body worn camera on and you really only put it into sleep mode when it's privacy or power failure. And when you look at the Axon Trail, you're going to see that Mr. Rayner's body worn camera was at 90%. So the point of the 30 seconds of video is, what did he see? What did he see in those 30 seconds? The guy that the state paid to come up here and give you his testimony couldn't point out a single thing. He's traveling around the world testifying 300 days a year. He's the preeminent expert in law enforcement tactics, and he tells you, I don't see anything criminal in the video from the first initiation. So, would the 30 seconds help you? What did he see coming around the corner? I would argue to you he saw nothing. He saw nothing, which further bolsters our claim that Mr. Wallace was doing nothing wrong. So how do we read Jason's mind? Well, we can look at the video. We can look at the video and assess his actions in the video. And I gave an example a few moments ago about some things that you readily come to mind if you saw a 30-second video. Writing a ticket, running radar, putting handcuffs on someone. You can read a lot of an officer's mind by just that 30-second video. But again, it seems like the state of Florida was in a different trial when they presented to you all of this weight on Roy Bedard, yet he gets caught in his own words, standing right here a few hours ago, saying, yeah, I said that. I said that is not how we approach a high-risk vehicle. That's what he said. And that's what's on the video. So the state, let's break this down here, okay? This vehicle is evading the entirety of the Volusia County law enforcement for the week. Because when you look at the Volusia Crime Bulletin, it goes out on 6/21. So on 6/21, up in Ormond Beach, there is this stolen vehicle report. And then 2 days later on 6/23, it's still out there and it hits a license plate reader in the area. And what is uncontroverted in this case is that a stolen vehicle is a high-risk vehicle. And if we move forward, we heard testimony, we saw pictures, we heard about the felony stop that happened as to the actual vehicle, which involved multiple officers, guns drawn, and a tactical approach. You see none of that in the video, members of the jury. What's uncontroverted is that there was not a 911 call complaining about Mr. Wallace. There was not a dispatch to 133 calling about something else. He wasn't flagged down. So you can eliminate from any reasonable consideration that any of those things prompted his response to 133. So then you consider the vehicle. And again, we go back to, we agree. If a law enforcement officer is acting reasonably, then he can get it wrong. And we're going to give them leeway. We understand that. But with great power comes great responsibility. It's not that hard to look at the side of the vehicle and determine that the lights look different. That there's differences to the top of the roof. That there's no door handles. Members of the jury, I am not putting a burden on Mr. Rayner that he needed to be Superman or have any superhuman powers. All I'm asking you to do is consider what's on the video in light of reasonable law enforcement actions. And what we heard from Mr. Bedard, what we heard from Detective Denardi, what we heard in sum from all of the law enforcement officers, that your powers of observation are what you hone. Those are the tools of your trade. You sharpen your sword. So you should be more perceptive. And it's unreasonable to suggest that on the longest day of the year when there's still some light in the sky, and I agree, there's not a lot of artificial light back there, but he has a flashlight. He didn't one time look to the passenger side of the vehicle. Perhaps if we would have had that 30-second video, we could either prove or disprove the fact that he pulled up on his computer that email that he may or may not have considered and compared it with the vehicle that he was coming upon. How is that an unreasonable call for action? It's not. There's no backup. There's no call for, how hard would it have been to call dispatch and say, do you have any more information? Have you seen it anywhere lately? So instead, the state would have you believe, inconsistent with its own expert witness, that that's one of the possibilities here. That he was approaching this high-risk vehicle in a parking lot without announcing his location, without any backup, and going immediately to the driver's side of Mr. Wallace's vehicle and restricting his free liberty. Immediately. So what's going on in Officer Rayner's mind in that point in time? What is Otha Wallace's state of mind when he has the right to be free from unreasonable intrusions into his liberty? And all of a sudden there's a flashlight in his face, and a person at his door, and a hand on his shoulder, and then another hand on his arm. And then when he tries to walk away 3 times, he's yoked and tussled with. How does that affect Mr. Wallace's mind? Are those actions reasonable? You can walk away if you're not doing anything wrong. Why does the state of Florida want you to so steadfastly ignore that fact? Because in order for you to convict Mr. Wallace, the state wants you to believe that anytime a law enforcement officer comes up to you for any reason and gives you a command,
Counsel, observe the golden rule, please.
wants you to believe that it's entirely appropriate in the United States of America in 2021 for a sworn law enforcement officer to come up upon somebody just because they want to and ask questions upon them and makes demands of them and put their hands on them. And there's nothing wrong with that, and you should just comply.
Counsel, observe the golden rule, please.
And that Otha Wallace should have just complied. That he should have just complied. Because, why? He wasn't in a stolen vehicle. Nobody called 911 on him. Nobody flagged him down. You don't see him doing any crimes in the video that we've looked at. Nothing. But he should just comply and sit down because he's in a high crime area. So your government argues that if Otha Wallace has the audacity to find himself in a high crime area, that he is immediately subject to inquiries about his address and his activities. And that's acceptable. That's lawful. That's reasonable. That's good faith. How has the state of Florida proven to you beyond a reasonable doubt that Otha Wallace didn't have the right to walk away? He tried to do it 3 times. 3 times. Bedard finally reluctantly agreed that. Donardi agreed that. Bedard agreed that he would not instruct his law enforcement students to detain a person if they weren't doing anything wrong. Oh, it must have been the cannabis. This is another side. We'll get to the cannabis in a moment, but this is obviously from the rear. But this is a very good representation of the vantage point that Mr. Rayner would have had when he came across the vehicle. And as we saw on the slide before, the lights are different. The lights extend into an area that was easily and instantaneously observable by Jason Rayner. It was so dark out there. I mean, the state of Florida would have you believe that you needed light vision goggles to see 1 inch in front of your face. I mean, you can see this, you can see this, and you can see this. And then you ask yourself, what evidence has the party with the burden in the case presented you to show what efforts Jason Rayner took to dispel that this vehicle was one and the same with the one in the crime booth? Where's the evidence? I challenge you, members of the jury, to look at every single piece of evidence in this case, and you will not find a shred of it. What you will find, which is very convenient from this theory that, oh, he's smoking a joint that he rolled with white rolling papers here. It's a Swisher Sweet. It's a Swisher Sweet. It's just, how is this isn't, probably, members of the jury, this isn't horseshoes and hand grenades here where you get close and you score a point. This is beyond a reasonable doubt to prove that he should be convicted of first-degree premeditated murder on a law enforcement officer. And the state wants you to disregard the fact that there's a brown cigar wrapper in here and a brown tip of a cigar in his hand? Do you see any smoke in the pictures? Do you see any embers in the vehicle? Do you see any cannabis? Did you hear one single law enforcement officer come and say, oh, you know what? We found all of this weed in the car. There was, obviously he was smoking. No, he didn't. No, he didn't. That's the quality and substance of the evidence that you need to say he was smoking cannabis in the car. But you don't have that. You have, again, a jump to conclusions. Here's a theory for you to consider, members of the jury. It's common sense. Okay? The state would have you believe that after he fulfilled his desire of killing a police officer, he stopped and bought some Swisher Sweets after the fact, on his way out of town. So if the basis of Mr. Wallace being detained is merely him sitting in his car, then how are Mr. Rayner's actions in good faith? How are they in good faith? How are his actions lawful? What evidence will the state of Florida present to you or sum up in their rebuttal argument to say that a law enforcement officer's lawful duty is to come up to someone who's sitting in their car, not doing anything wrong, and instantly detain them and refuse to provide information about the reason for the detention? I'd love to hear that piece of evidence in the state rebuttal. But what they did do was they paid Mr. Bedard $4,500 to help you look the other way, to impress you with the fact that he's traveling around the world and he knows everything about police training. Yet, when it came down to it, he admitted that Rayner's actions were not consistent with approaching a high-risk vehicle, that he did detain him and box him in. And it doesn't make a lot of sense with just common sense or police practice of de-escalation that if you're just acting proactively and trying to gain rapport amongst the community whom allegedly believes that you're, purveyors of justice, that you would instantly detain them. There was this long discussion about, well, now we've readdressed policing and we want them to be more friendly and we put them on bikes and we want them to, have better community ties. So the way that we do that is when we see a person sitting in a parking lot, you go up to them and you immediately block them in and get 4 inches from their face and shine a light in their face as well. How does that play into Mr. Wallace's state of mind? The state would like you to focus on the hour-long presentation from the FDLE analyst about the phone mapping rather than have you dive into that matter. Or maybe you should consider the hours and hours of testimony about the things that didn't matter, like that my client's DNA is on his gun that he was found with that he admitted to using, or the shell casing, or the hat. The state hasn't met its burden. They want you to believe that Mr. Wallace's mere existence in a high crime area allows law enforcement officers to just get it close enough. The car looks close. He's got something in his hands. He's probably doing something wrong. What's the baseline? What's the baseline? We want to talk about the baseline in a church on a Sunday morning. What's the baseline in an apartment parking lot at 8:50 at night? People in cars. People in cars. Close enough doesn't cut it here, members of the jury. It's beyond a reasonable doubt. Where's the taser? Does the state present the taser? Does the state prove beyond a reasonable doubt that there couldn't have been a reach for the taser at any point in time? You have pictures of the taser latch being undone. I mean, the question is more of, evidence integrity than anything else. I mean, they keep the most important evidence in a paper bag. They throw it in the trunk of the car and take 2 pictures and then call it a day. How's the state of Florida's presentation of this case shown that Mr. Rayner did not go for his gun? It's convenient that there's all of this evidence about what you can clearly see on the video or what's not in dispute, but the really mind of the matter comes in those seconds that you can't see in the video. That I would argue to you, Mr. Wallace's testimony was absolutely consistent with the totality of the evidence and the medical forensic evidence in this case. Mr. Rayner was taller by several inches than Mr. Wallace. The trajectory is consistent with the way that Mr. Wallace described this event happening. Anywhere, the medical examiner candidly told you 6 inches to 2 feet. That's not inconsistent with what he said happened. It's not inconsistent with them tussling and fighting. So what is going on in Mr. Wallace's mind when he has a light shown in his face, when he's not doing anything wrong? Did the state of Florida present to you some manifesto that he was drafting at that moment in time about the ways in which he could execute a peace officer? What's going through Mr. Wallace's mind when Mr. Rayner comes and blocks his free liberty, the liberty that he had every right to exercise because he was not doing anything wrong? And how did Mr. Rayner coming around and blocking that make him feel? Who initiated the encounter? The state conveniently ignores that premeditation has to be considered in light of the circumstances of the killing. If Mr. Wallace wasn't doing anything wrong, then he created no circumstance under which Mr. Rayner had the right to approach, detain him, put his hands on him, and ask him about his activities or his address.
How's it going?
Do we see any attempt in those few seconds to discern that this was or was not the stolen vehicle? No, we didn't. No, we didn't. But according to the state of Florida's theory of defense, theory of the case, if you're in a high crime area, you just comply. You just answer the questions. You just sit down. Because when you're in a high crime area, you don't have the rights that everybody else has. Otha Wallace wasn't deserving of any scruples to determine whether he was doing anything wrong. So let's dive in a little deeper and let's consider this idea of excessiveness. I would argue to you, members of the jury, there's a vast difference between the way an officer would approach someone if they are executing a warrant on a serial killer versus somebody that's trespassing or at worst and maybe smoking a joint in his car. Oh my God. So it's a sliding scale. It's reasonableness, okay? It's reasonableness. I would argue to you that there is no credible evidence to suggest that Otha Wallace was smoking cannabis in his car. Okay? And even if he was smoking cannabis in his car, he deserved to get tussled and and grabbed and pulled on and treated like that? Is it consistent with somebody knowingly engaged in criminal activity to walk towards a law enforcement officer with a joint in their hand? I would argue no. So the state would have you believe that, oh, it was the cannabis that was detaining.
What's going on?
Well, you can use your common sense, rely on the video. Again, disregard everything that I have to say. But what the video unequivocally shows is that Mr. Rayner had no opportunity to view anything until he has already detained Mr. Wallace. Mr. Wallace is about to be detained in a millisecond here. Use your common sense, and by all means, listen to expert Bedard. Okay? Because he told you, you can't see what's going on in his hands here. So what's going on in Jason Rayner's mind? What is this element of proactivity that's existing where this community caretaker function is such that just to strike up a conversation, the best way to instill confidence would be, I'm going to go over and surprise the heck out of this guy sitting in his car. Members of the jury, there is no credible evidence to suggest that the stopping of the car, the exiting of Jason Rayner, and the walking and approaching the vehicle was founded upon anything other than a desire to make contact with somebody. And we don't know the intentions beyond that. And if the state hasn't proven to you with the substance and quality of this evidence that it was something lawful, that it was something reasonable, that it was something in good faith, then I would argue, foremost, you have to consider that in your inquiries of premeditation and unlawfulness. You should also consider it on the ultimate issue of guilt. So what evidence has the state presented to you to justify the parking, the exiting, and the walking? Because as we know, what's uncontroversial here is that Othel Wallace becomes detained at this point in time. And you can only be detained if you're doing something wrong, and there's no evidence that Othel Wallace is doing anything wrong. So rather than do any investigation or consideration into the genesis of this encounter, they'll just go ahead and charge Mr. Wallace with first-degree murder, and we'll backfill everything in later. We won't give any regard to the context of the social media posts. In fact, what would be better to do is we'll go ahead and we'll get like 20,000 pages of it, and we'll pick out the ones that look really bad. And we'll give those to you for
Objection,
consideration.
improper argument, Your Honor.
Sustained.
What's going on?
Sit down. Sit.
Sir,
Can you sit down? I'll talk to you.
Why does Mr. Wallace have to sit down? What has he done? What has he done?
Thanks. Don't do this. Sit down.
why you asking me to go up here?
Do you live here? Yes or no?
What's going on, though? Who, Charlie?
Is this a reasonable approach to instill confidence in the community? Why do you live here? Sit down, let me grab your shirt while I'm doing so?
Objection, Your Honor. That's improper argument. Let me correct, he didn't say that.
Well, the jurors will rely on what the evidence shows you. Counsel are free to argue what they may show, but it's your decision to determine what happened here. You may proceed.
What did Othel Wallace do up until this moment to deserve a hand and a push and a grab? Absolutely nothing. Absolutely nothing. So, to be fair to both sides, you say, well, what's the context of this encounter? What's the context leading up to this? And as we've gone through in a laborious fashion in this trial, and I've also touched on it here, or without context? We don't know. It's uncertain. There's theories that are unproven. In fact, there are theories that are, I would argue to you, objectively disproven by a fair look at the video. The state disregards the context. The state would have you look the other way. The state hasn't proven to you beyond a reasonable doubt that the social media in this case allows you to read Mr. Wallace's mind beyond a reasonable doubt. Where's the context? Members of the jury, the proactivity that caused the ire of my client enough to post these disgusting things on social media, his worst nightmare, became his reality.
Stop. Stop. Stop, man.
How has the state disproven that Otha Wallace's version of events is inconsistent with the truth? How has the state of Florida proven to you that Amanda Dickens' testimony should be relied upon? Here's me. We had this conversation with Jason Rayner about him going.
Hello.
Based on
Mommy.
Hey, no yelling.
I know. Mom. I know. I just want to let her know because my boyfriend, he had a party and she could be giving him a call. But I can't talk to her because I need to go.
Go 7 feet apart from me.
I feel like it's not a little bit wider, a little bit wider. My job. I'm trying to help them. Oh, no, I can move under the baby. That's Can we tell her now?
Yeah,
Can you
we're
please,
gonna
can you
talk.
do me a favor?
We're gonna talk.
May you just tell her to that I said to grab my boyfriend Damien and just meet me at the police station on 92. Tell her, please.
Yep.
Tell her I said just please. Oh, I'm sorry.
Okay. Okay.
There is absolutely no discussion between Mr. Rayner and Miss Dickens in that video. Again, undermining the context that the state would have you ignore. Mr. Wallace said some awful things on social media. He acknowledges that. He doesn't deny it. The state has argued in its closing and undoubtedly will argue to you again in its rebuttal presentation of all of these gross admissions that were made and, that he was trying to blame it on Instagram. Well, rely on your recollection, members of the jury. Was there a clear and fair opportunity for Mr. Wallace to answer the questions when Mr. Lewis was screaming at him and dancing around in circles in front of him? Where's the context? The Instagram audio post is an inartful dying declaration. He expressed his characterization of Rayner's actions towards him. Ultimately, has the state of Florida proven to you beyond a reasonable doubt that Mr. Wallace was unreasonable in feeling that Jason Rayner was fucking? How is the state of Florida proven to you beyond a reasonable doubt that it was unreasonable for Mr. Wallace to be on edge, to be scared? Is it unreasonable for a person, for Mr. Wallace, sitting in his car doing nothing wrong, to have this happen to him? Is it unreasonable that in light of an innocent mind, to be yoked up by your collar like that, to be on edge, to have your heart racing, to maybe not be thinking clearly, to start to sweat, to start to have those fight or flight instincts that the human being that Otha Wallace is undoubtedly had in that moment. But the state would have you just rely on a few of 5,000 Instagram posts. So you have to ask yourself, members of the jury, where else does the evidence of premeditation come from? Does it come from the gun? Does it come from the FDLE tracking? Does it come from Roy Bedard? Does it come from the fragments or the photos or the uniform or any of the other alphabet soup ATF, the FBI? No. The only evidence of premeditation comes from the social media, which again, members of the jury, you have to understand in context. The message was inartful, the message is unproductive, but it's in response to culturally significant events that are happening at the time. Culturally significant events that Otha Wallace testified were in his mind at the time that he was being yoked out of his car by a law enforcement officer. Argue that there is a complete difference in the state of mind presented in a social media post by one who looks differently than Otha Wallace in speaking about a different context to which he is inartfully articulating online. It's a completely different mindset. His indignation is justified, his method of delivery was not. But the method of delivery is different than the state of mind. What causes more of a state of mind? What sheds light more on a person's state of mind? When they're in their car, being approached, being startled in the way that they react to that? Or vapid banter on a medium for the purpose of vapid banter? At no point in time does Mr. Wallace come up in the initial encounter and be disrespectful towards Mr. Renner. So let's rectify those two. The state of Florida's only evidence of premeditation in this case are social media posts that happened weeks prior. So to hold him guilty of premeditation based on these posts, one would have to logically assume that for weeks, he harbored this hate, he harbored this malice, and finally had the opportunity to live out his intentions that he posted online. How is it reasonably possible then for a person with so much hate harboring and manifesting in their gut for so long to call the very target of these posts sir, to act calmly, to try to walk away 3 times? How is that consistent? How can the state of Florida even get close to a premeditated or murderous mindset when the best that the state of Florida can say justified this was maybe a tip, maybe marijuana, maybe a high crime area, and wants you to ignore the state of Mr. Wallace's mind when this is happening to him? Only after and in response to what Mr. Wallace was subjected to did he draw his weapon. He was responding. He was defending. Members of the jury, I submit to you that in this 30-second video, you can read Otha Wallace's mind. The pages of his mind begin with confusion, and they end with fear for his life. And while he's retreating, he perceives a threat. The threat of a law enforcement officer reaching for his waistband inches from his gun. Now, the state took a lot of time to establish this chain of custody laboriously. The gun belt got off. I took it. I put it in there. Stood it up. secured it nice and safe in this paper bag. Here's the Axon guy. We weren't going to ask the Axon guy anything in our direct examination about the 30-second video. Not going to ask him anything about that. But what he told you was the sensor is all the way down. You have to pull it down. He couldn't tell you exactly how far, but you have to pull it all out. And the state of Florida made the big deal about that gun always being in the holster, never being removed from the holster. Yet 4 minutes later, on the Axon audit that you'll see, there's a signal firearm draw. How reliable is that information? Otho Wallace does not have the burden of proving that he was justified in using deadly force. Instead, the state of Florida has to prove beyond a reasonable doubt that the defendant was not justified in using deadly force. So it is unreasonable to use deadly force when, after doing nothing wrong, having a light shine in your face, being ignored when you're asking a reasonable question. Okay? There was, I think, 4 minutes of going back and forth of, well, you didn't answer him between Mr. Lewis and, well, you did answer him, you didn't answer. Otho Wallace doesn't have to give him an answer. And if we're holding law enforcement to a high esteem, in a high position of authority, how is it unreasonable to expect an answer to a question? Hey, why are you detaining me? How can the state of Florida get close to a premeditated or murderous mindset when all of these things happened? And Mr. Wallace only acted in response. He's justified in using deadly force if he reasonably believed. Reasonable belief. All that Mr. Wallace is asking you to do is be reasonable. Is it reasonable for him to feel in fear for his life when everything that happened up to that point was excessive? It's one thing if Mr. Wallace is credibly doing something wrong. It's one thing if Mr. Wallace is a serial killer, if he has known violent tendencies, and there's a level of tactical force and response and guiding of his body, then it would absolutely be unreasonable for us to argue to you self-defense. But excessiveness and good faith and reasonableness are sliding scale common sense determinations.
Objection, Your Honor, a misstatement.
I will instruct you on the law, okay?
So any amount of force in this situation is excessive. Because if you're not doing anything wrong, you can walk away.
Try not to use the word "you" for them.
If Otho Wallace is not doing anything wrong, Otho Wallace can walk away. And that's exactly what he tried to do. And what's been, again, covered in all of the unimportant pieces of evidence in the case is that the state of Florida still needs to prove to you that Mr. Rayner was acting in good faith. That he was acting in good faith. That Mr. Wallace, it's irrelevant as to the status of Mr. Rayner as a law enforcement officer if he's not acting in good faith, if he's not acting lawfully, and his actions are excessive. Judge Zambrano will instruct you on the law on this matter, on the justifiable use of force. And you'll hear some discussion about the duty to retreat, and a discussion about certain scenarios in which a person is presumed to be in reasonable fear. And it's very important that you pay careful attention to that law. The judge is the authority about the law. In no way, shape, or form am I suggesting to you that if, in my banter with witnesses, that I am correct over Judge Zambrano. I would submit to you that I have done my best to accurately elicit that information, but Judge Zambrano is the authority on the law. And what I would like to help simplify it with is this, is that Otho Wallace had a gun in his pocket. We're not disputing that. It's his gun. If you want to take time to debate that element, you're welcome to. He had the gun. It's his gun. That's the murder weapon. End of story. And he had it in his pocket. And the only reason why he's at any jeopardy of having this carrying a concealed weapon situation thrust upon him and in his face is because Jason Rayner prevented him from walking inside and putting his gun away. I mean, you see Othel Wallace walking out of his car. The car door is open when Rayner first gets out. So is it unreasonable? Is it really even illegal for a person to have a gun in their pocket when they're walking from their door to their car for 10 steps, maybe? So the way that can wrinkle itself in the law in this case is the law will suggest that if he's doing something wrong, which we would submit that he's not, then a person has a duty to retreat before they use it. Mr. Wallace was trying to retreat from jump one. So we embrace that law. It doesn't change the analysis or you have to do any creative leaps to get there, because from jump one, what we believe the entirety of the evidence, not just the cherry-picked evidence, but what the entirety of the evidence shows is that Mr. Wallace intended to exit his vehicle and walk to his apartment, and he was prevented from doing so by Mr. Rayner. Initially when he got out of his car, and then he tried to get away again, and Mr. Rayner put his arm on him and pushed him a little bit, forced his way back, asked him questions, tries to get around again, and then he's met with another hand. And then he tries to walk away again. And he gets a horse collar. And then he tries to swoop under his arm again, and he sees Rayner going for his waistband. And I will comment on this, members of the jury. Mr. Wallace was nervous. He was testifying for his life today. And what he could have said is made up some story to you and said, absolutely, he drew the gun and pointed at me. He gave you his best recollection of what he remembered in the moment in time. But you have to view it in context. How is it reasonable at all for a law enforcement officer to go for his duty belt when the encounter started for no reason and the citizen walked away? How is that reasonable? It's excessive is what it is. However, if an officer uses excessive force to make an arrest, what was Othel Wallace even under arrest for? So if he's not under arrest and force is being applied, then it's not good faith. What is he under arrest for? He's not in a stolen vehicle. There's a Swisher Sweet pack in the car. The jury, a fair deliberation of the facts of this case requires a number of things. And I would say that among the most important of them are that you listen to one another and respect the deliberative process. Each and every one of you has to make an individualized moral assessment about what the state of Florida has proven in this case. And in doing so, you should internally consider all of the evidence and debate amongst yourselves. And a full and fair deliberation of the matters in this case requires consideration of the heavy, heavy burden that the state of Florida carries in attempting to get a conviction. And I would ask you, because of the heavy burden, the state gets to have the final word in this case. Certainly as a criminal defense attorney, I'd lobby to change the law if I could, but we accept that that is the case. And it should be that way, frankly, because the state of Florida has the burden. But I would encourage you to consider, when Mr. Larissa gives his closing remarks to you, to in the deliberative process, consider what would Mr. Shoemaker say to that point? What would Mr. Probisco say to that? How do we think that Mr. Wallace would respond to that? That would be a fair deliberation. And what's interesting about the law as it applies to reasonable doubt is that the state uses, the law is that you have to have an abiding conviction of guilt. you probably discern from all of the procedure and all of the formalities that the words matter. We take a lot of time to arrive at the words that we're using in the law that the judge will instruct you on. And it's interesting that the word conviction is used because conviction, just like many words in the English language, has multiple interpretations. And it's also synonymous with the feeling, and in this context, the conviction that one would have. And we don't use conviction in the terms of, I'd really love a steak for dinner tonight. We use the term conviction when we're talking about true core beliefs. All ethics, our religion, our family, what is our conviction? That is the standard here. An abiding conviction, one with which you hold to the same regard as your most deep and core values. And if you don't have that abiding conviction, Mr. Wallace is not guilty. And again, on behalf of Mr. Wallace, we would absolutely acknowledge, and we do not want part of the deliberative process to suggest in any way that law enforcement is an easy job, that it's a job that should be overlooked, it's an unnecessary job, or that any verdict that you render in this case would be a disservice to Mr. Rain. We acknowledge that. We embrace that, and we agree that that's the case. But with great power comes great responsibility. We understand that there may be deliberations, and you are absolutely free. Again, I can't stress this enough. If something that I've said, if something that Mr. Shoemaker has said is turned you off, consider the evidence. What we're saying is not evidence to you. But if you're going down and you're thinking, well, even if Mr. Rayner was in the wrong in some way, did he deserve to die? I think that's a fair question for debate. And what I would argue to you is that the question should be posed as, was it reasonable for Jason Rayner to make both Wallace feel like he was going to die? On June 23rd, 2021, both Wallace had the right to be free from unreasonable intrusions into his privacy and into his liberty. If you determine, which I believe the evidence supports, that Mr. Wallace invaded on that right, he was not acting lawfully. If he's not acting lawfully, that has an effect on Mr. Wallace's state of mind when he is battling with someone who is unlawfully detaining him, and that affects both of Wallace's human instinct and plays to a self-preservation state of mind, not one of premeditation. I thank you for your time, and I thank you for your consideration in this matter. And I hope that your deliberation in this case finds Mr. Wallace not guilty.
Thank you. We're going to take about a bathroom break, 10-minute break. All rise, the jury. Thank you. Be seated. Okay, you have the defendant? Yes, we do. Yes. All right. You bring the jury in. All right, so jury. All right, jury is present, you may be seated. Mr. Larissa, your rebuttal.
Thank you, Your Honor. Good evening, folks. I will agree with Mr. Probisco on one thing. It's been a long day. And you know, while I get to go last, and usually that's considered an advantage by some, y'all been here a long time. I just ask you to please bear with me as I talk to you. I'm not gonna scoff. I'm not gonna make fun. I'm gonna talk to you. And all I want you to do is listen to me. And your decisions, what you decide, that's yours. You own it. Juries are to be trusted. Trusted to care. Trusted enough to be able to abide by the law as you're instructed. You're trusted to do that. So I want to point out some things to you. I'm not trying to tell you what to think or what your decision should be, but I want to make sure you understand certain things. And the first thing I want to say is, I was wondering for a while which trial we were in. Was Arthur Wallace on trial, or was Officer Rader on trial? Was the state of Florida on trial? But I've been around long enough to know that defense attorneys like to blame everybody but their client. They're not going to blame their client.
Mr. Steen.
The bottom line is premeditation. I think Mr. Probisco said it. There's no evidence of premeditation. But folks, let me ask you about something common sense. The defendant posted that he wanted to get pig's blood on his hands and on his boots. Believe it was. He posted within 15 minutes. His own words. The defense says, can't read Arthur Wallace's mind. I submit to you, you don't have to. All you got to do is listen to them posts or read those posts and listen to that message. I mean, it'd be one thing if he didn't kill Jason Raynor, if he didn't plant a bullet in his brain. But that's what he did. Why? Because his rights were violated according to the defense. So he can shoot Officer Raynor, he can take that gun, pull it out of his pocket, point it at his head and pull the trigger because his right was violated? What did Mr. Bedard say? What does the law say? The law says that you do not resist a police officer with violence. The judge is going to tell you that. And you may not like it. Some of you may say, well, what about us? What about our rights? That is why we have a courtroom. That is why the defendant gets his day in court. And you, members of the jury, are the ones that are going to decide if he's guilty or not. There's a lot of talk about Officer Raynor and that he was somehow wrong. You remember Mr. Dipper, the fellow with the, I think he had a mohawk. He came in, he lived right across the street. Right across the street from those apartment complexes. How many times did he say he had, how many bullet holes did he have to repair in his house that he was renting? None. None. The reality of our world today is that we need police officers to help to maintain order, to protect us. There's a lot of communities that need that help and that assistance. And law enforcement response. Is it wrong for a law enforcement officer to walk up to somebody and say, hey, how you doing? Do you live here? Is that wrong, folks? Use your common sense. What did Officer Raynor do? He asked, where do you live here? And what did he get? He didn't get an answer. Now, Mr. Probisco says he don't have to. And that's right. We don't have to do anything if we don't want to. But the law steps in. If we could do what we wanted all the time, then there'd be no consequence, there'd be no order. We would live in a world where people could do whatever they wanted at any time. And the reality of our world now is there is violence each and every day. All you have to do is turn on the TV. What do they talk about? Violence. Do you want, or excuse me, does society want a community where you're afraid to go out and walk around?
Sustain, please abandon.
Yes, sir. Yes. I know y'all seen this video a bunch, but I want to play the video for you in real time. Mr. Lewis is going to help me with this. And then I want to show you a slow version. But before we play that video, and I know you probably ain't going to again, but I want to kind of lay some context here. This video lasts about 42 seconds. The defendant's tires you can hear the gravel, you can hear it screeching out. He's leaving. 42 seconds from the time Officer Rayner says, "Hey, how's it going? Do you live here?" until the defendant is leaving in the car with Officer Jason Rayner laying on the parking lot with the bullet in his head and his eye hanging out. And at 21 seconds, that's when Officer Rayner keys his mic. That's when he starts to call for backup. 21 seconds. At 24 seconds, the defendant's hand is on, Mr. Officer Rayner's hand is on the shoulders. And we'll see this in slow motion. At 28 seconds, there's a shot. So from 24 seconds to 28 seconds, 4 seconds. 4 seconds, the defendant pulls a gun, points it, and shoots Officer Rayner in the head. Let's talk about moving and getting underneath and pulling that gun out and trying to get away 3 times. Folks, the whole situation only lasted 48 seconds, 42 seconds. That's it. Think about this. Officer Rayner didn't know that the defendant had a gun in his pocket when he came up. And there's talk about this stolen vehicle and how, there's no evidence of that, and a marijuana cigarette. All of those things are just the state giving you the information it had. You can accept it or reject it, but you know what? It doesn't matter. Officer Rayner was trying to figure out what was going on. His right, his duty, his responsibility. He saw a car, he saw a person in it, and he did, what he did was absolutely okay, it was lawful. He was walking up, "Hey, how you doing? Do you live here?" How was that wrong? And the defendant, how did he respond? He didn't respond. He didn't answer the question. Jason, can you key that up for me? Just play the video, just straight through.
How's it going? Do you live here?
What's going on?
Do you live here?
Why you ask? What's going on?
Sit down. Sit. Sit.
Sir.
Can you sit down? I'll talk to you.
Okay. Come on now.
Sit.
Come on now. Don't do this.
Sit down.
Why you asking me do I live here?
Do you live here? Yes or no?
What's going on though?
Who? Charlie 777.
No, back up.
Stop, man.
Go back, man.
Now, I want to play it slowly, and I'm going to ask Jason to stop it every now and again so that we can, I just want you to see it. I'm going to make a few comments. You can agree with me or not. Go ahead, Jason. Okay, now stop for a minute. It's a Honda No doubt about that, and it's gray. Keep going. The door's open, and Otha Wallace is starting to come out before Officer Rayner gets there. Keep going. Keep going. Stop. Now, what I want you to do is watch this. Watch what he does with the phone. Go ahead, please. Stop. 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 Keep stop. Some people say, or there's some argument that was, he was trying to conceal a marijuana cigarette. We don't know if it's a marijuana cigarette. What I submit to you he was doing, he's right-handed. He has a gun in his pocket. A police officer is coming up. What does he do? He takes that phone and gets it out of his right hand. He's freeing up his right hand, folks. Before there's even been a touch or anything, he frees up his hand. He takes that phone, clear as day. He moves it. What's Officer Rayner doing? He's asking him to sit. Hadn't touched him at this point. Go ahead. He touches him lightly on the shoulder. Go ahead. Now stop. Did you see that little tap? Excessive force, right? What do you think? Go ahead. Now stop. Did it again. Stop. He's turning into it the way I see it. I mean, make up your own mind. But Otha Wallace is, does he look like he's afraid, folks? Does he sound like he's afraid? Does he? Or does he sound like he doesn't like what Officer Rayner is doing? Go ahead. Now, let me show you, stop again. You got, now, once you pay attention, you got one hand, one of Jason's hands on his right hand on the left shoulder of Wallace, and then his other hand with the flashlight is over there. Both of his hands are up here. Okay, go ahead. Flashlight in his left hand, right hand on the shoulder. Stop. That portal happens when Officer Rayner starts calling in. Officer Rayner's got one hand on the shoulder and one hand on the right. And what does Wallace do? He creates space, which I think he also said, but not, folks, I submit to you, not to try and get away. Keep going. Stop. He's turning. Keep going. Stop. He's turning towards the car, folks. Now he says that he had the gun in his pocket. Maybe did, maybe didn't. Maybe it was in that car door and he's pulling it out. I mean, it's for you to decide, but where is he trying to get away from Ray? He's going back towards the car. Go ahead, Jesse. Now, yeah, that it's over. That I submit to you that is Wallace standing up. Officer Rayner's falling to it. He's falling to it. He's shot. He's shot. And ultimately, he's going to die from that shot. Okay. We'll take that off. Again, I'm not going to try to tell you what to think or how to interpret this. But according to Wallace, Officer Rayner's reaching for his waist. I'm not exactly sure what that means, but Officer Rayner's got a hand here and a hand here. Wallace turns toward the car. And in 4 seconds, folks, 4 seconds, he shot in the head. Now, how in the world is he going to reach down and go for it? He's trying to stop. He's trying to stop him from moving. He's trying to get control, sure. He doesn't know what he's got, but what he knows is when he walks up and asks, hey, how you doing? What's going on? Do you live here? Wallace gets out of the car and won't answer. It's what's going on? What's going on? As a law enforcement officer, he's trained. That's as the guard said. That's a distraction. He's trying to distract the officer. Look, we're not saying that Wallace did anything wrong. We're saying the question is, was what Officer Rayner did reasonable under his training and circumstances? Listening to the defense, you think he was the one that pulled the gun and shot somebody. He was doing his job in a high crime area, and somehow that's wrong. Is it wrong for a police officer to go out in the community and try to engage folks, find out what they're doing, especially in a community where there's been 3 shootings in the last several days? Where there's been domestics, where there's been narcotics trafficking. Look, it's a tough world out there. Most folks never know that. They don't experience. Is it somehow wrong for a police officer to go in a community that suffers from those things and try to make it better? Isn't that what Officer Rayner was doing? Did Officer Rayner say anything? Excuse my language, but did he say, hey, motherfucker, what are you doing? Did he walk up there and threaten? Did he have an ass in his hand? Did he have his hand on his gun? No to both of those. Did he grab him and shake him? Did he threaten him in any way? Get back in the damn car, I'm going to bust you. No, he didn't. He said, sit. Get in the car, I'll talk to you. Wallace wasn't having any of it. But somehow, Officer Rayner is the bad guy. And, God forbid, that his liberty be restricted while Officer Rayner's trying to figure out what's going on with reasonable questions. I just put a bullet in his head. Arthur Wallace put his phone from his right hand to his left. And then he waited until Officer Rayner had one hand here and the other hand on his mic. That's an opportunity because Officer Rayner's distracted. Not only that, I agree, yeah, he was worried about law enforcement coming. He didn't want to deal with them. He wanted to get Rayner and go. Now, Mr. Probisco has really, he's minimized those posts. And you know what, folks? At the end of the day, you can believe the defendant's story if you want. I was just so fed up with what was going on. I shouldn't have posted them. I think he even said I should have took them down, but I couldn't. Sure, he could have took them down. He never took them down. how do you folks, how do you ignore the fact that he posted, we got those posts real quick. Yes, get them for me. Here's one. We are at war. Johnny Bolton died at the hands of a trigger-happy SWAT team. These crackers are not far from seeing the blood of their own flowing, thick in the gutters of America. How about the other one? One day I will take great pride and honor in getting me some pig's blood on my hands and boots. He did. Well, almost. He got Officer Jason Ranger's blood on his vehicle when he shot him in the head and left him for dead. Now, you can say, oh, it's just coincidence that he posted these things and then shot somebody and now claiming it's the officer's fault. If you think that's reasonable. I mean, it's up to you. You know, it's very important for you to judge credibility. The defendant took the stand, and I challenge you to judge his credibility. You saw him up there. I'm not going to regurgitate everything he said, but you heard him, you saw him. You saw how he acted. You saw how he answered questions or didn't answer questions. You know, I think Mr. Provisco was implying that law enforcement had such an interest in this case. And of course they do. You saw how it affected Officer Dickens when she had to watch and relive finding Officer Jason Ranger. Sure, they want the just and right resolution. So he implied that they would lie or that they would manufacture evidence or somehow come in here and try to pull the wool over your eyes, to use his term. But what about him? What about the defendant? Does he have an interest in this case? Does he have something to lose? Does he? According to the defense counsel, he does. Is that a reason for him to stretch the truth a little bit? Or maybe a lot? You think about that, and then you decide. You know, there's been a lot of talk about if this, then that, and that, you know, that if you find that Officer Rayner acted unlawfully, then Wallace is not guilty. Folks, that is not the law. The judge is going to explain the law to you. The reason that the law says you can't resist an arrest or resist an officer with violence, you have to look no further than this case right now. Why that's true. Why that is the law. Law enforcement officers, hey, they choose to be cops. They choose to go out there and work in dangerous conditions. They do it all the time. But the law recognizes and understands that as human beings out there putting their life on the line, and listen, 42 seconds, after 28 seconds, Officer Rayner was shot in the head. 28 seconds from the time he got out of his car and walked up there. Think about that for a minute. 28 seconds to make decisions, try and figure out, what do I have here? Oh, go on and walk behind the car. Sure, while you got a man that you don't know coming out of the car, it's dark, and they won't answer your questions. What's he going to do? Just say, ignore him and the officer's safety concerns and walk around to the back of the car, which he couldn't do anyway. You heard Letitia, the defendant's ex-girlfriend, say that there was bushes up there. That car was backed in. Whether Wallace did it on purpose or not, it doesn't matter. Officer Rayner couldn't see the tag. Somehow he should have, by God, he should have went and looked at that. Again, who's on trial here? Is it Officer Rayner or is it the defendant? 28 seconds. And he's supposed to figure out that ain't the car. 28 seconds. Now, again, you can choose not to believe that that's one of the reasons why he stopped, or you can choose to believe it. It's up to you. But is it reasonable? If the actions that Officer Rayner did consistent with that, and even if it wasn't, it doesn't matter. He has a right to walk up to a person and say, "What's going on? You live here." And a defendant cannot resist with violence, period. Now, sure, if a police officer pulls out a baton and starts beating somebody for no reason, you got a right to defend yourself. What did we see here? There was 4 seconds from the time that Officer Rayner keyed his mic till he was shot. What did he do? Excessive. There's a tap on the shoulder, and there's a alleged horse collar. That's not what the defendant called it. What did he say? He was yoked, or he was trying to yoke, he was pulling. And I'm not even sure what yoke is exactly. Maybe y'all do. I don't. But that's what it said. Wallace shoved the officer, created space. When he shoved that officer, folks, he committed a crime. Now, if he wanted to contest why the officer approached him, if he wanted to establish that the officer was wrong, that's what a courtroom is for. Otherwise, what, we're going to have folks shooting law enforcement officers because they don't agree with why they were pulled over? Or they don't agree with the reasons the officer wants to talk to them? Do we live in a society where officers can detain people for no reason? Absolutely not. And there are rules and laws in place to protect your rights. But those laws and rules, they don't give a defendant the right to pull a gun, point at an officer, pull the trigger, shoot him in the head, leave him for dead because they didn't agree with what the officer was trying to do or the questions the officer was trying to ask. That's not the way it works. And maybe you don't like it. I don't know. Maybe you do. But that's the law. I submit to you that Officer Rayner couldn't have put his hand down towards his waist. He had one hand on his mic, one hand on the shoulder, and 4 seconds later he shot and dead. The defendant was already moving, but where he couldn't see Officer Rayner, look at the video for yourself. The video's the best evidence. But look at it. He turned away. He was going for the gun, folks. That's exactly what he was doing, and it's exactly what he did. When did he ask to leave? Did he say, "Officer, I'm leaving. I don't want to talk to you"? Did he ever say, "I don't want to talk to you"? He talked to him. He engaged in conversation with him. What about that? Never once. Not once did he say, "Let me go." In fact, if you really look at that, analyze it yourself, but I submit to you that Wallace was in control. Rayner was trying to get control. Officer Rayner wanted to, and he was trying to do it in a polite way. Now, Mr. Provisco kind of scoffed at them, but I tell you,
Objection, man.
he was courteous and professional. You know what? He gave the defendant benefit of the doubt. And the defendant gave him a bullet in his head. That's what happened. I thought I heard somewhere that the Officer Rayner blocked in the car. Well, how did the defendant how did he get away? How did he get out and drive through? He never blocked the car in. Wallace got in it and took off. And you know, how often is it? Well, I should say, you are fortunate here that you have statements from the defendant that were voluntarily made. I mean, nobody was interrogating Wallace when he said he wanted pig's blood on his hands and boots. He posted that on his own and admitted it was his own words. Not like he was put in a box and questioned for 3 days before he made the statement. Folks, you should consider that, I submit to you. And the other post as well. Nobody made him do it. He wanted to do it. Now again, you can believe it was just coincidence that he made those posts and 3 weeks later, Officer Rayner's dead and he shot him. You could do that if that's what you believe, if that's what your deliberations reveal. But it's one heck of a coincidence, wouldn't you agree? And how about some of the language? Pigs. Practice. Last time I checked, those aren't terms of endearment. And you know, it's uncomfortable to be confronted with having to sit and make decisions when you've got that kind of negativity, that kind of energy. And because it makes most folks feel uncomfortable. But it made Wallace an interview, made him mad. He was mad and enraged over what was going on. It's clear from his posts. And again, is it coincidence that less than 3 weeks later, he kills a police officer? Off the victim. Can you play the audio, the story, I think it's called, please? I know y'all heard this one. Again, we don't need to read Wallace's mind. He's given us his mind. Can you play it?
No. I want y'all to know something, man. I love y'all. I want y'all to know something, man. I love y'all. Black power. Stay strong as a nation. Keep fucking fighting. Move fucking forward. Don't let these pussy ass pigs fuck with you. I love y'all. Black power and shit.
Consider. He had just shot Officer Rayner in the head and left him for dead. Never mentioned self-defense, does it? Never says I was in fear of my life. Does it sound like he was in fear? Or does it sound like when he starts talking about don't let these pussy-ass pigs fuck with you, that he was excited about it? You decide. And I'm sorry to use that kind of language, but that's what it is. That's what he said. And folks, you can't consider that. It is a window into his mind. You are fortunate to be able to have evidence to consider. Now again, okay, he was just all pumped up with adrenaline. Folks, it was 15 minutes later. He's driving away, ultimately gonna head up to Snellville. And he says, don't let these pussy-ass pigs fuck. I think it speaks for itself. What do you think? There's no doubt he said it. He admitted it. you'll have instructions about the execution of a legal duty. See, the instructions, one part of the instructions, look, these instructions are created by lawyers, so they're not necessarily the easiest things to understand, but they're the best attempt to try and guide you. But don't ever forget your comments. Take that back, dear way. It has some good, honest conversation. Look, there's an instruction that says under the felony murder about the resisting officer with violence, it says that Officer Rayner has to be in the lawful execution of the legal duty. But there's another instruction I want to draw your attention to, always but. That but says that, and we have that instruction handy, the one about you cannot resist. I think I know it pretty well. That instruction says that an individual cannot resist a law enforcement officer with violence if the officer was executing a legal duty. Let me talk to you about that for a minute. Engaged in the execution of a legal duty. We know what legal duty. First off, you'll get another instruction that talks about law enforcement officers. What's their duty? To deter and detect crime. Is there any debate here that that's what Officer Rayner was doing? The defendant says he didn't know, never met him before. There was nothing going on between those two. Officer Rayner's doing his job. He's trying to protect the folks in that community, in his jurisdiction. That, folks, is engaging in the execution of a legal duty. Understand, it says execution of a legal duty, not lawful execution of a legal duty. You don't get to attack police officers because they might make a mistake about the law. Think about this for a minute. 28 seconds into his encounter, and he's shot in the head. 28 seconds for him to process what's going on and try to apply that to the law. It's an unrealistic burden. That's why, as long as he's engaged in the execution of a legal duty, detecting crime, and he's acting in good faith. What was it that Mr. Probisca said a lot about, is that good faith, that he was implying it was bad faith? Judge for yourself, folks, but 28 seconds. What did Officer Rayner do that was bad faith? He was investigating. He wanted to know if the guy lived there. There'd been shootings in that area. Nipper had 9 bullet holes in his house. Officer Rayner didn't have to be there. That's the sad irony of this. But he took pride in his job. And he put himself on the line. He put his life on the line, folks, and he lost it doing his job. He didn't lose it doing something bad or something unlawful, illegal, something in bad faith. He lost his job because he didn't go in there with his gun pulled. And he didn't go there and be more forceful on his commands. He was given the defendant the benefit of the doubt. He was trying to be polite and courteous. And that's the sad reality of what happened here. Doing his job and trying to do it in such a way that will be respectful. And he got it. He got it. We know he was reasonably known to be a law enforcement officer. The defendant helped us with that. Now, it also goes on to say that if the officer uses excessive force, folks, I'm not going to beat you over the head with that one. I mean, you've got literally about 28 seconds and just to watch to reach a conclusion about excessive force. Excessive, and then the self-defense claim. Let me talk about that for a minute. It says that a individual is justified in using deadly force. Now, deadly force, taking a gun, pointing it, shooting it, and putting that bullet in somebody's head, that's deadly force. Nobody's arguing with it. But they can only use deadly force if there is an imminent meaning immediate, right then and there, threat of death or great bodily. Is that what we're getting? What do you think? It's a reasonable person standard, folks, on whether or not there's reasonable fear. Would a reasonably cautious person in the defendant's situation have done what he did? A reasonably cautious and prudent person, would they? Mr. Probisco is challenging the posts and such because, as we argue, it's evidence of motive. We don't have to prove motive. But juries, folks like to know why somebody does what. You can choose to believe Mr. Wallace's version. You can choose to believe it, or you can reject it. Too many coincidences. Wants to get the blood of police officers, pigs, on his hands and boots. It's war. Blood running in the gutters of America 3 weeks before, and then Officer Rayner's dead, and then 15 minutes later, I submit to you, bragging about it. And again, no mention of self-defense. Not with Miss Bodison. Remember the lady that wrote, that was, I think, the girlfriend of Wallace's brother, Octavius, I think. No mention of self-defense. Because it wasn't. But, again, who's got an interest in the outcome here? Who has more of an interest in this outcome than Wallace? Nobody. Nobody. Mr. Lewis was asking him about, why didn't you just sit down? And he said he wanted to leave. He didn't want to sit down. And then he shoots Officer Rayner. He had a duty to avoid that. Call it a duty to retreat. He had a gun in his pocket. Now you can buy a story if you want that he had put it in his pocket because he was getting ready to leave and take it in the house. Doesn't matter. He had a gun in his pocket. He didn't have a permit. Didn't want to admit that, but he did. That's carrying a concealed firearm. Mr. Probisco kind of talked about it in passing. If you're engaged in criminal activity and try to use the stand your ground or self-defense, if you're engaged in criminal activity, which he was, contrary to Mr. Probisco's dissertation, he has to retreat if he can. What does that mean in this case, folks? It means he should have sat down. He could have sat down. And he admitted he could have. But he didn't. He could have got back in that car. And we wouldn't be here today. He didn't. Listen to the jury instruction. Another thing. I won't play it for you. You'll have a chance if you're so inclined. But at the end of the shooting, after he shoots Officer Rayner in the head, he says, "Fuck that man." I submit to you that's what he said. Didn't want to admit it. He said, I think his words were something like, get the fuck back, man. That is not, I submit to you, that is not what he said. But he doesn't want to admit that because that's further evidence of his intent. He wasn't in fear for his life. Folks, it's sad and it's disturbing, but he wanted to kill him. And he did. Fuck that man. Evidence of fear or disdain. It's your call. It's your decision to make. And there's no evidence, even the defendant never said that Officer Rayner drew his weapon. Quite frankly, once he was under attack, once he was getting that violence, that force directed on him, I submit to you would have been justified to pull his weapon. But he didn't. He tried to control the situation and he couldn't. And he lost his life. And, you know, Mr. Probisco was kind of making fun of what we did with our case. Like that we...
Thing.
Okay. Let's just say he was less than complimentary.
Objection.
For real.
He was less than complimentary about some of the things we did. Should we not present the evidence that that the gun that killed Officer Rayner did not have Officer Rayner's DNA on it? Should we not do that? We don't know what's going to happen in the trial. We don't know what evidence is going to come out. Mr. Probisco acted like we did. We were preparing for trial, as we should. A police officer in our jurisdiction, in our community, in our state, was shot in the head and died. We're not gonna leave any stone unturned, and folks, we make no apologies for it. You deserve to get every bit of evidence, every piece of evidence, and then you consider what it's worth. You make that decision. The phone records, again, less than complimentary about, well, wait, like we're wasting your time, weren't we? We're being thorough, folks. Again, we don't know what's going to come out. We don't know who's going to testify and what they're going to say. We have to be ready for anything. And again, we don't apologize for that. It's our duty to give you everything that we have. And then it's your decision to decide if it's important. We don't presume to what you're going to think. We just give it to you and you decide. We know for sure that Officer Rayner's gun was never pulled out because of the audit trail. Now, you got the audit trail, and I want to try and just correct something here. Mr. Probisco said something about the alert going off. I think the implication was that that Officer Rayner pulled his gun. You know how that Axon, the alert is if you pull your gun, and I think the testimony from the guy from Axon was, if you pull it out far enough from that sensor, then it automatically triggers the body cam if it's not on. Not only that, it sends an alert to that audit log saying weapon pull. But what else did they tell? What else did that man tell you? Childs or something like that, I believe. He said that if you have a lot of officers in close proximity and they pull the gun, then every body cam in that zone will get the audit alert of a gun being pulled. And I'm going to show you before we're done the video of the officers. You saw it before. It was the Harper, where the officers were running. They even fall down as they're going to try and get to their colleague, their officer who's lying there bleeding on the ground. And their guns are pulled. Of course, Officer Rayner's log is going to reflect that. But it was several minutes after he was shot by Wallace. Folks hold dear the Fourth Amendment. You know, nobody wants their privacy violated. But let's put this into context in this case. There was talk in opening by, I think, Mr. Schumann about the right to be secure in your homes and it's saying it's safe. That's true. But that doesn't mean a law enforcement officer can't come up to you and ask you where you live, if you live.
Counsel, be careful, golden rule.
Okay, my apologies. That doesn't mean that an officer can't ask somebody, hey, how's it going? Do you live here? The Fourth Amendment is not a ticket. It's not a pass. It's not it's okay to shoot a police officer if they violate your Fourth Amendment rights. That's not the law. The court is where you address it. Otherwise, it'd be chaos. Mr. Probisco is talking about a civilized society. So if your privacy right is violated, you can park a bullet in a police officer's head? Is that what it means? What do you think? Could have answered the question. I mean, he lived there. That's what he said. I think Letitia was a little bit different. She didn't say he lived there, but upon cross with Mr. Probisco, she said he was welcome there. I mean, yes, I live in this apartment. How hard is that, folks? What's wrong with an officer asking that? And why wouldn't he answer? Oh, because he don't have to. You're right. He doesn't have to, but there's consequences for actions. Talking about your deliberation, want to make sure it's clear. You get back there and some of you say, I think it's felony murder. Some of you say, I think it's premeditated. Just want to be clear, as long as all 12 of you agree it's one or the other.
Judge Lee object based on previous objection. The comment.
Sustain. Rephrase your comment.
You can choose premeditated or felony. What the instruction will tell you is that so long as all 12 of you agree to first degree murder, by whichever theory, that's valid. That's what the law says. That's what the instructions say. Sleep mode. Oh, sleep mode. the state was I won't say accused, but it was implied that the state was trying to distract you by some of the things that we brought up, like the DNA evidence, like the shell case. But this fleet mode is, I submit to you, distraction. It's an attempt, like some of the other arguments that the defense is making, for you not to focus on what you need to focus on. Objection.
Overruled.
That encounter, that 48 seconds is all there was of what happened. That's it. Anything else about what was on, what could have been on there, that's speculation, folks. And what does the reasonable doubt standard say? It's not a speculative doubt. It's got no place in your deliberations. You can decide to consider it, but consider what? What is there to consider? He had it on sleep mode. Could have been for privacy reasons. They don't know. It's speculation. And it has no business, it has no relevance to the case. That video captures the entire episode. Everything. Even the defendant in this. And the defendant flee, taken off. You'll get an instruction. It's consciousness of guilt, fleeing from the scene. You can consider that to be evidence of of guilt. Why not stay? Well, the defendant says he was afraid that he could get shot by law enforcement. But 15 minutes after he shoots and kills, or shoots Officer Rayner, he dies 55 days later. He's posting. He's bragging. Don't let the pigs fuck with. Excuse me, pussy ass. Does that sound like somebody who's afraid law enforcement's gonna shoot him? Sounds like he's inviting the confrontation. It was a public page. It's a public, anybody could see it. Everybody could see it. Think about that. He wasn't restricting it to people that he knew or that were friends or whatever you call it on Instagram, followers. He posted it for the whole world to see. Consider that. And consider the tone. I mean, I don't have to tell you about the tone. You heard it. You heard it. He builds. I love y'all. I love y'all. He fucking fighting. He moving fucking forward, and then don't let them pussy ass pigs fuck. You can see, you can hear it. That is an indication of his mind. It's not. We're not reading his mind. We're hearing his mind. Make no mistake, this ain't a mind-reading episode here. This is us using common sense to the words he used and the things he did. Went to Gainesville, Georgia. And he could have shot all the police that were there. Yeah, he could have, I suppose, and got killed himself. Is that maybe something? I think, I submit to you. The reason he didn't fight, because he didn't want to die. He didn't want to die. When he had Officer Rayner alone in that secluded parking lot in the dark, knowing he had a gun and knowing that Officer Rayner giving him the benefit of the doubt, he had an opportunity. I'm not saying he planned to kill Officer Rayner weeks in advance. He was predisposed. He wanted to kill a police officer, and the opportunity presented itself. Now, you can reject that if you want, but again, 3 weeks before, he's saying, I want to get pig's blood on my hands and boots. 3 weeks later, Officer Rayner speaking.
It's been an hour.
I'm about done, Judge. I'm about done. Can you play the Irvinson video?
So that's what we have time to describe. Where is he? 5-7 Central Rescue Code. Right. Where is he? Sergeant gunshot wound. Who shot him? Come on, buddy. Hey, it's gonna be all right. Yeah, Officer John, he's shot. Where's it at? Hold it, buddy. Hold it. Hey, just talk to me, man. Talk to me, Jeff. Where's the guy who shot him? Who shot him, buddy? Oh, man. Just hold on, buddy. Just hold on. Central Rescue Code 3. See if we can hear you. God bless, man. Oh, my goodness. Get something to hold pressure. Just hold. Here. I got it. He got my shirt. 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 10-3. Damn, man. Gunshot wound in the head and one in the chest. Come on, man. Just keep talking to me, buddy. Just keep talking. Get rescue here now. You're gonna be all right, buddy.
You'll get these instructions at the end. You must follow the laws as set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law. In this case, all of us are depending upon you to do to reach a wise and legal decision in this matter. Let me remind you that it is important that you follow the law as spelled out in these instructions in deciding your verdict. There are no other laws. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Now, folks, I'm not going to tell you what verdict you should render. What I'll tell you is what my challenge to you is that you do your due. You consider the evidence and you deliberate. Follow the law. Follow the law. And reach the only verdict that is fair and just and is supported by the law. Thank you for your attention. And thank you for what a day I don't think any of us will ever forget. Thank you for being here today. And thank you for doing your duty as jurors. God bless you.
Thank you. You may be seated. Ladies and gentlemen, I have been informed that the jury has announced that they have a verdict. Before we accept the verdict, I just want to say a few things before the jury comes into the courtroom. I know that this has been an emotional case for both sides, and that emotions are raw, Your feelings are riding very high right now. But for over 250 years, we have resolved our differences in this fashion. Respect for the jury's work is paramount because they have a very hard job to do. We are here to respect their work, whether we agree with it or we disagree with it. The decorum of the court will be maintained. I will not permit any outbursts, expressions of emotions, disagreements, or agreements with a verdict. Any violations of the rule will be met swiftly. So you must remain seated and stoic while we accept the verdict. If you want to disagree with it, you'll do that outside of the courtroom. If you don't think you can stomach the pressure of this, then please leave the courtroom right now. Bring the jury. Okay. All rise for the jury. You're seated, Your Honor. You may be seated. Ladies and gentlemen, I have been informed that there is a verdict. Number 48, are you the foreperson? Would you fold the verdict in half and hand it to the bailiff, please? Will the defendant please rise? The verdict appears to be in proper order. In the Circuit Court, 4th Judicial Circuit, in and for Clay County, Florida. State of Florida versus Othel Wallace. Case number 2021-303-347 CFDB. We, the jury, find the defendant, Othel Wallace, as follows, as to count 1 on the indictment. Guilty of the lesser included offense of manslaughter. Special findings. If you find the defendant guilty of manslaughter, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant carried or used a firearm? Yes. So say we all. Juror number 48. Madam Clerk, poll the jury.
Juror 125. Is this your true verdict? Yes. Juror 117. Is this your true verdict? Juror 33, is this your true verdict? Yes. Juror 48, is this your true verdict?
Yes.
Juror 65, is this your true verdict? Yes. Juror 74, is this your true verdict? Yes. Juror 98, is this your true verdict? Yes. Juror 35, is this your true verdict? Yes. Juror 54, is this your true verdict? Yes. Juror 74, is this your true verdict? Juror 70, I'm sorry.
Yes.
Juror 121, is this your true verdict?
Yes.
Juror 90, is this your true verdict?
Okay, thanks. You may be seated. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that our jury's deliberations, discussions, and votes should remain their private affair so long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether or not you wish to preserve your privacy as a juror. I'm going to ask you just to step into the jury room, and we have some additional paperwork for you, and then we'll formally release you from jury service.
All rise for jury.
Okay, Mr. Wallace, the jury having found you guilty, I'm going to go ahead and order you be taken into custody. A bond will be revoked. And is either side asking for a pre-sentence investigation, or you're asking for a pre-sentence investigation? I'll order a pre-sentence investigation. I'll schedule sentencing, probably 60 days down the line. I don't have a date right now. So we will just, is there anything else we need to address?
Yes, sir.
Okay, we will be adjourned. Thank you.
I will say that, please.
Okay.